Please rise.
Take a seat. This is Good Schools Missoula versus Missoula County Public District, Missoula Sacred Heart School Foundation, various individuals. A couple housekeeping matters before we start. Council, I appreciate your filing, first of all agreeing and then filing the stipulated pre-hearing order. Our ordinary schedule is to take an hour and a half for lunch and recess at 4:30, but I need to leave finish this today by 4. I have another appointment at 4:30. I have to be across town at 4, plus I lose my clerk at 4. So would it be all right if we only took an hour for lunch and started at 1 o'clock?
That's not a problem.
The next matter is on timing. We only have today to do this, so what I will ordinarily do is to have my clerk keep track of your time, and you can use it any way you want. You're charged for your cross-examination, you're charged for calling your own witnesses, you're charged for your arguments, and do you think it's appropriate that we divide the time in 3 segments? Each of the 2 defendants and the plaintiff?
Well, Your Honor, what we had done
Yes or no?
Oh, I think it is appropriate for everybody.
Okay, that's fine. Do you agree with that? That it's, we'll divide the time in 3 segments. The plaintiff has 1/3, and the Missoula County Public District has 1/3, and Loyola has 1/3.
Yes, Your Honor.
That's fine. Any other matters we need to take care of before we start? Plaintiff first.
Well, I think we intend to offer, I mean, this is not a suit on the merits, of course. It's one on attorney's fees with, based on a couple of things.
I should tell you a couple of things. I've read the Supreme Court opinion, I've read your briefs, I've read the proposed findings, and I've reviewed the file. So I am aware of what we're doing today.
Okay.
Yeah.
We have our exhibits marked copies for everyone, including the court.
Are there any challenges to the exhibits, or would you like to enter them en masse?
Oh, well, Your Honor, we need to see what they're going to be admitting to see if we have an objection to them.
You haven't seen them?
No.
Well, we've seen throughout the course, I'm sure we've seen them, but I don't know exactly what they are. Today, I don't know what they're seeking to admit.
If I may, Your Honor, since I'm more familiar with the file, these are the same, the first 48 of the exhibits we proposed to exhibit are the same 48 we put in the record 2 years ago with the same numbers exactly. So all the parties have had them for quite some time. That's why we proposed to admit them en masse, if possible, to save time, rather than putting in a foundation for each and every one.
You accept that, or?
Well, Your Honor, I guess what I would suggest is that perhaps they could be admitted, since you're going to be sitting both as finder of fact and the judge on the issue of law. And then if they refer to one, we could interpose an objection if we feel like it's hearsay or some other objection. Foundation.
May I approach?
These are my copy.
Yes.
Your Honor, if I may, my name is Elizabeth Cullivan. I represent Missoula County Public Schools.
Okay.
And we may have foundational objections to some of these exhibits.
Okay.
Most of them have been reviewed during deposition.
You'll make your objections when we make reference to them.
Yes, they may be different basis than the foundation's
All
objections.
right. Keep in mind that 2 of you, although on the same table, are not one entity. Ready to call your...
Your Honor, just if I could, I wanted to make one clarification or ask you if you would agree with. The way we had set this out in calling these witnesses was for the purpose of bringing them up only one time. So, just so I'm clear that if I'm examining a witness, that time's charged to me, and then we'll go in order asking questions of that witness, and then that witness will be excused and not called again for the rest of this one.
You agree with that?
Yes, that's right, Your Honor.
And also, just to make clear on, well, Janet Scott is not available today. She was supposed to be here. She had a family emergency. we're going to just simply admit her deposition so that we can refer to it in argument as evidence, and that's been agreed to by counsel.
So stipulated.
Okay. And Dan Funch, Carol Bellin, and Judy Smith would be adverse witnesses, so even though that I'm calling them up for purposes of order, I will treat them as hostile witnesses.
Okay, make sure you mention that point when you call them.
Yes. Pursuant to the order, we had a 10-minute opening statement
Okay,
scheduled. So I will begin with that, Your Honor.
is it necessary?
It was asked for by other counsel, so we just simply agreed to it.
Is it necessary? I mean, it's your time, you can spend it any way you want.
If Your Honor doesn't feel you need a review of the legal issues, we'd be
What are you
happy
going to
about
tell
that.
me that I haven't already read?
Probably nothing.
Then we can,
The reason I ask that is you have a lot of witnesses here, and at 4 o'clock, we shut down. So just be aware of the time.
then we'll move directly into witnesses, Your Honor. We'll call Tom Sturgis.
Please come forward, raise your right hand and be sworn.
Do you solemnly swear the testimony you make will be the truth and the truth and nothing but the truth, so help you God?
And when I have any questions of the witnesses, nobody will be billed for that time. Take it equally out of your respective times.
Will you please state your name for the record?
Thomas Andrew Sturgis.
And Mr. Sturgis, what is your relationship to the Loyola Sacred Heart High School Foundation?
I'm currently president of the board of directors.
Okay. And in the time period of 2005, 2006, what position did you hold?
I was a board member.
And can you explain just briefly for the court what the function of the foundation is?
Sure. The foundation is a nonprofit corporation that exists for the benefit of Catholic education in Western Montana.
And just in a sort of day-to-day, what type of things would you do?
We go through fundraising and managing our assets, including the endowment and making tuition assistance payments to the schools.
When you say tuition assistance, is that basically scholarships for students?
That's right.
And does the foundation have any day-to-day control over the activities of Missoula Catholic Schools?
No, we do not.
As president, are you familiar with the foundation's purchase of the Roosevelt School property?
Yes, I am.
And what role did you play in that purchase?
I was part of the negotiating team, a number of current board members and former board members that helped negotiate that process.
And can you summarize, just for the court briefly, what the reasoning behind the foundation's desire was to purchase that property?
Sure, we needed a building. We had been in possession of that building on a lease basis and had a number of years left on the lease. And we enjoyed the building, we enjoyed the location. We had a lot of students coming from the surrounding area. It was nice and centrally located, and we enjoyed the building and wanted to buy it.
Did you receive when I said you, I meant the foundation. Did the foundation receive a request for proposal to bid on the property?
Yes, we did.
Did you have it in your exhibits? I don't want to have
What
you
you
look at
looking for?
exhibits. The request for proposal sent out from the school.
I don't think so.
Okay. And what's your last number?
Our last one.
Yeah, it was 53. You know what I mean? I approach the witness.
Certainly.
Handed you a document.
I need it.
Oh, sorry, Your Honor. I wasn't sure. I was going to ask to admit unless you can stipulate to it.
We'll stipulate.
Okay, then we'd ask that that be marked as Exhibit 54, Your Honor.
54?
Yes. Does the clerk need a copy, Your Honor?
Yes.
Any approach?
Or she can use that one if that's the one you're going to actually offer. right?
Okay, that's fine. Are you familiar with this document, Mr. Sturgis?
Yes, I am.
And what is your understanding of what this document is?
Well, this was, as we moved to a competitive bid process, this is what we received from the public school system to make sure that there was a consistent set of responses and timelines for the process of the sale.
Okay. And did the foundation submit a proposal in response to this request?
Yes, we did.
May I approach, Your Honor?
Yes.
Will counsel stipulate to the admission?
Just a moment, please.
The number you were proposing for this?
Yes, Your Honor, we'd admit this as Exhibit 55.
So
Objection to what's been marked 55?
no objection, Your Honor.
Admitted.
Is this the proposal that the Loyola Sacred Heart High School Foundation submitted in response to the request?
Yes, it is.
Now, were you involved in drafting this document?
Yes, I was.
As part of the proposal, did the foundation agree to limit the use of the property in any way?
Yes, we did.
And how was it agreed to limit?
Well, we agreed to use it the way that it had always been used and the way that we were using it for its current historical uses as a school and secondarily as a polling place, playground for the neighborhood, Cub Scout, jamborees, and YMCA basketball, things like that.
And is this something that was requested by the public schools in their request?
I think there was a lot of discussion about it back and forth, and we knew that that was generally the will of the board and the will of the neighborhood, and certainly, I don't recall whether it was asked or whether we put it in proactive. I think it was asked.
Prior to submitting that proposal, did you have the chance to review any written appraisals of the property?
I briefly reviewed the Stevens appraisal.
May I approach, Your Honor?
Yes.
I'll give you that one, Your Honor. It's already been marked as Exhibit 15. I've handed you a copy of a written appraisal conducted by Tom Stevens dated August 30th, 2004. Is this the written appraisal you were referring to?
Yes, it is.
Any objection to 15?
No, it's actually our exhibit, Your Honor.
Your Honor. In reviewing this document, did you come to an understanding of what Mr. Stevens appraised the property, its fair market value?
Well, I mean, as I said, it was a cursory review, but it was very clearly laid out as $1.45 million in the appraisal.
And in the proposal, or excuse me, in the bid that was given in response to the proposal by the public schools, what did the foundation bid for the property?
$1.5 million.
Following submitting that bid, was that accepted by the public schools?
Yes, it was.
And did the foundation, in response to that, enter into a buy-sell agreement with the public schools?
Yes, we did.
Do I read here that the appraisal was done after the bid was made by Loyola?
Prior to, it was prior to 2004. Is the 2005 was the process of the buy-sell. The spring of 2005.
Yes, Your Honor, the bid was put in March 22nd, 2005. The appraisal was dated August 30th, 2004.
I wondered that because I saw when he was describing the highest and best use that it was says on page 12, additionally, the current lessee has tendered an offer and, must be misspelled, were offered to purchase property which would retain the improvements in their existing form to be used as a grade school. Had there been any restrictions on it at the time he made the appraisal as to it continuing in its current form? Because earlier he said the highest and best use is for the development of single-family homes.
Well, Your Honor, Mr. Stevens is going to testify, and I don't want to, basically what he'll testify to is that he came to the conclusion that the highest and best use was to continue using it as a grade school. But there was no restriction placed on Mr. Stevens, and he can clarify in his testimony, that there's no restriction put on him that he had to appraise it only as a grade school, if that answers your question.
No, it doesn't. What's it mean then when the current lessee would retain it as a grade school? Are they talking about the school?
Well, again, yes, at that time, the Missoula Catholic schools through the Helena Diocese were leasing the property.
Oh, okay.
Yeah, so, and just to clarify for the record, they had made an offer prior to this bid process of $1.1 million.
So how much of his appraisal is based on it being available to be used for anything? And how much is it restricted by the current lease that was on it?
Okay. Well, again, I don't want to testify for Mr. Stevens because he'll be called next, but my understanding is that he was not restricted in appraising the property. He appraised it based on its use to the general public. But you certainly can ask him questions when he gets up there.
Do you have the buy-sell in your exhibits?
This is what you mean? Purchase and agreement?
Yeah, the cover sheet too.
Well, it's all in there except for the
Let me see. Years.
39.
May I approach, Your Honor? Handing you a document that's been admitted as Exhibit 39. Is there any objections? Foundation? Okay. Mr. Sturgis, is this a buy-sell agreement that was entered into by the foundation?
Yes, it is.
Do I have 39?
That was in the original document.
For the record, Your Honor, exhibits 1 through 53 are all our exhibits. Those are in the group we just tendered to you. We will not object to any of them since they're our exhibits in the first place.
And are you familiar with that buy-sell agreement?
Yes, I am.
Were any provisions included in that buy-sell agreement restricting the foundation's use of the property if they purchased it?
Yes, there was a restrictive covenant that was added that allocated the current and historical use of the building. And I think it specifically called out use as a polling place, as a community playground, and use for the community.
What paragraph?
That's what I'm looking for. 'Cause I think wasn't there an attachment to this? That was also,
Exhibit 40 if you look at it.
oh, it was in the closing.
Well, if you look at, Your Honor, what I'm referring to is, yeah, paragraph 8, subparagraph C2.
Paragraph 8, you say,
Yeah, thank you.
Under closing,
yeah.
C states such additional documents might be required, and that would be my next question. Mr. Sturgis, you referred to a restrictive covenant. May I approach, Your Honor? And the hand has been marked already as Exhibit 40. Is that the restrictive covenant you were referring to?
Yes, sir.
Okay, and I think you've already told us what your understanding of the restrictions were.
Right.
As part of the buy-sell agreement, are you aware if the public schools agreed to make any repairs on the building prior to transfer of ownership?
No, we didn't have it in there.
To clarify, you included nothing in the
We
buy-sell
included
agreement?
nothing in our buy-sell agreement that required them to make any additional changes or repairs.
Going into the purchase, did the foundation have any knowledge of repairs that were going to needed to be done?
Yes, yeah. Originally, we had looked and certainly there were several components of the infrastructure of the building that were aging that we had requested in initial discussions prior to the best and final process. But as part of the competitive bidding process, we just decided to have a clean transaction.
Are you aware if any monetary concessions were made by the public school district to pay for any repairs after transfer of ownership?
No,
Did the foundation fulfill the terms of the buy-sell agreement?
yes, we did.
Did the foundation execute and record the restricted covenant that we marked as Exhibit 40?
Yes, we did.
In addition, was there a right of first refusal included in the buy-sell agreement?
Yes, there was.
There's section 2.
It's in 40.
But there's actually a separate document recording.
Or I was just asking that. Are you aware if the foundation recorded a right of first refusal in connection with the sale of the building?
Yes, we did.
And how much did the foundation pay for the Roosevelt School property?
1.5 million cash.
All right. As a result of this litigation, has the foundation incurred attorney fees?
Yes, we have.
Okay. Are you aware of approximately how much that is?
I haven't seen a number recently, but I think it was somewhere in the neighborhood of $13,000, $15,000, right around there.
So the right of first refusal gave the school district the right to seek more money from another buyer on the same terms and conditions that were made with Loyola Foundation.
Essentially, Your Honor, yes. They went out and found a third-party buyer for whatever price they had to bring that to the district to allow it to be bought back.
And it had to be on the same conditions, and those conditions included the restrictive covenant of continued use for elections and things like that, and playgrounds and things.
Actually, my understanding is the restricted covenant only ran to the foundation as owner.
What do you mean by that?
The returns again.
I saw that the right of first refusal,
Exhibit 40, paragraph 2.
Yes. The term of the covenant, paraphrasing, Your Honor, shall be binding upon the declarant and any lessee, tenant, or assignee of declarant, I think that's a typo, taking possession of the property.
oh, okay.
Other than a bona fide purchase,
Okay.
subject to the right of first refusal.
So the school then could try to find a better buyer, and they would not force that, what I'll call the better buyer, higher price buyer, to be subject to the restricted covenant.
That's correct, Your Honor. I have nothing further for this witness, Your Honor.
I have no questions, Mr.
Make a statement.
Thank you, Your Honor. Mr. Sturgis, my name is Roy Andes. I'm counsel for the plaintiffs in this case, Good Schools Missoula. You said you were on the negotiating team for the purchase of Roosevelt School. Let me run some names by you and ask you if they were also on the negotiating team. John Giuliani,
Yes.
Dave Mahalat, my old friend,
Yes.
Katie DeSoto,
No.
she was not,
No.
Wade Deal,
No.
Bill Schaff,
Yes.
Scott Anderson,
No.
Steve Hall,
Yes.
Patrick Haggerty.
No.
But you consulted with all those persons that I just named, the negotiating team did during the course of doing the
A
negotiating?
couple I don't know, so, I would say consulted in maybe a discussion, but never part of any rigorous part of our process. The negotiating team was comprised of about 4 of those individuals that you mentioned, and then when we came up with our conclusion, we ran it by the board for final approval, and that was really the negotiating process.
So some of those individuals I may have just named were on the board perhaps instead?
That's correct.
I see. And I presume that the negotiating team consulted with other people within the Missoula Catholic Schools family of interest during the...
No shortage of opinions, certainly.
Okay. Were you involved in the preparation of discovery responses, probably 2.5 years ago by Loyola Sacred Heart Foundation in this case?
Spring of 2005?
Sounds right. Is that,
Yes.
you were involved with that?
Yes, the issues, documents in question.
Okay, and did you at the time review documents that were presented to us from Loyola Sacred Heart Foundation in the form of disclosure?
I'll have to elaborate, sorry.
If I were to tell you that Loyola Sacred Heart Foundation disclosed a packet of documents, probably 1,000, 1,500 pages, were you aware of that?
This is as part of the proceedings from a couple years ago that we had to disclose as the foundation.
Right.
Probably, they came from a variety of sources, so I'm aware that we had a disclosure packet, but I'm not aware of anything that was in it.
So you didn't review that packet yourself?
I can't say that I did.
At the time that Loyola Sacred Heart Foundation proposed its purchase of the Roosevelt School, you were aware that there was an existing lease to Missoula Catholic Schools for the property, right?
I was aware.
And was it also your awareness and your team's awareness that that lease would survive the sale of the property?
Yes.
So in other words, whoever bought the property, you understood, had to take it subject to a 4.5-year lease.
That's correct.
And therefore, if that lease was a good price, it would be probably easy to get bidders because they would be getting a good return on their investment. You understood that?
I assume so, yeah.
On the other hand, if the lease was less than a good price, it was going to be hard to get bidders because they were going to take it subject to a lease with a bad price on it, right?
Yeah, I'm going to object to foundation.
I certainly can't tell you what a good lease is or a bad lease.
Well, I'm just asking you what your understanding
I don't
was.
understand your question.
Sorry?
I don't understand your question. You understand this question?
Not necessarily.
Try it again.
I'll try again. Thank you, Your Honor. Okay, you understood the purchaser, whoever that might be, was going to have to take the property subject to the lease. In other words, the lessee would continue. You understood that?
I understand that.
So if the lease was at a price that was not a good one, that purchaser, that was going to discourage purchasers. Was that something you understood at the time?
No, I'm going to, again, object to foundation. Mr. Sturgis has no specialized knowledge in this area.
It doesn't matter whether he has specialized knowledge or not. I want to get what knowledge he does have, that's all.
Do you have any knowledge about, well, how about this? Was that a factor in your consideration? Is the I would call it the renewal of the lease?
Well, I guess the foundation's concerned, the schools had a number of years on the lease. I think it was 3 or 4 years on the lease. Our interests were in longer term than that. So, we didn't really factor that in to our discussions. We worked off the $1.45 million appraisal, offered a competitive bid for that. So we didn't have a tremendous amount of knowledge of the lease. We knew it was $60,000 a year. That was about the extent of it. But I don't recall factoring that into our negotiations.
Well, let me be very blunt. Was it not discussed among members of the negotiating team that, in fact, the existing Catholic lease on the property was below what would be a market value?
There was a number of discussions I know that went back and forth during the course of the process. I don't recall any specific discussions with our negotiating team internally. We had a number of reasons why we thought that the property, the value, why we wanted to pay less than $1.45 million. So there were a number of discussions about that, whether it was the boiler or the lease or a variety of topics. But, no, we didn't discuss that as a negotiating team.
You didn't discuss it, or you don't recall?
I don't recall discussing it. It certainly wasn't a key part of our negotiation process.
So if we have documents suggesting otherwise, you weren't party to those documents?
Have to see them.
So did I understand your testimony to be that with regard to the covenant that we were just discussing, Exhibit 40, I believe it was, I mean, approach?
Yes.
Or do you have Exhibit 40 there?
I'm running out of room. I do.
You want to direct your attention to, I can need to approach if you've got the document.
The second page, paragraph number 2. Did you understand that this covenant would expire at the end of Loyola's ownership of the property?
Item 2, repeat your question.
Did you understand that this covenant would expire at the end of Loyola's ownership of the property?
I knew I can't say that I knew that it expired.
But you knew that Loyola would be free to sell this without the restriction of the covenant, did you not?
No, not necessarily.
What did you think it meant? It says that it runs, shall
Yeah.
run with the property.
Sure. If you look at the offer, we were going through, they asked, would we be willing to continue, with checkbox? Were we willing to allow it to be continued to use in this historical fashion? Yes, yes, yes. Right of first refusal, yes. So, we were complying with what we thought would be the right way to approach the negotiation. But what I can say is we had no discussions about using it for anything other than use as a school.
So it was convenient for Loyola's purposes to impose this covenant on it. It didn't affect your planned uses in any way.
It's convenient for.
For- It was convenient for Loyola because it didn't affect your planned uses in any way.
That's right. We certainly wanted to keep the school the same way as it had been used.
But you weren't aware that this covenant would expire on Loyola's resale of the property?
At the time, no.
Not at the time, but you are now?
I am now.
So you
Very-
bought it with the idea that you would have to keep it open to the public until the end of time?
My recollection is that as part of the negotiation process, we had offered it up. I guess I just personally had not thought about what happens when we sold it. Never really entered into our conversations that we were going to
Sell it.
sell it. I should probably add, this was our intention from the get-go and still is today. That is the home of St. Joseph's School, as long as it's there.
Why was then there a need to even have the covenant? If you were going to use it as a school and have it open to the public forever, you were careful to put that in there. But on the next paragraph, it said, but if you decide to sell it, you can sell it to anybody and build houses.
Yeah.
Am I right that seems to be the effect of the,
I would so argue, Your Honor.
well, that seems to be what it says.
Your Honor, if I may, I guess there's a point of question here, is who drafted the document? And I didn't ask that, but that may shed some light on why that's in there.
Why is it in?
Because the public schools drafted the document, they put it in there. I don't know why they put it in there. And that's why Mr. Sturgis really can't testify to it.
So you were a negotiator and not a finalizer?
I was a negotiator. I was not the signer of the document, but, again...
I ask these questions because the plaintiff makes a big deal out of this. He said, what a sweetheart deal for you is that you buy it and you make sure the agreement says that only for public use in schools. Oh, but if you sell it, you can, all that vanishes.
All I can say is that never in the negotiation process, we never discussed that. We always went in good faith that this was going to be the future home for St. Joseph's School. And I think since 1873, with 137 years of Catholic schools here in Missoula, I think we have a sterling reputation of being good neighbors, and in all that time, never
Never sold your property.
sold our property, and I think a lot of those who've been around Missoula are aware, there've been a lot of opportunities, and I think our 137-year commitment says a lot.
Go on.
Thank you, Your Honor. Do you have Exhibit 55 handy?
I do not.
Oh, well, I'll give you a copy then. And I've highlighted it there so we can find where we're talking about quicker.
Oh, I'm sorry. I did have that.
That's okay, you can use mine.
All right.
And I'm gonna have to look over your shoulder if I may.
Okay.
Did you say 55, 50?
55, Your Honor.
This one.
Is that
That's the Loyola Sacred Heart proposal.
the offer option?
Right.
Okay. Okay, I've highlighted it there on, in paragraph 4. This was apparently taken off a form provided by the county, correct? Originally. We're marking up a form given to you by the county.
Right, so this was what we got from the county, and then we tried to respond directly in the yes/no format to what they had requested.
The last thing I've highlighted there on the page reads, buyer agrees to execute appropriate documents that would preclude subdivision of the property. Yes, no, and you checked no. But apparently in the covenant, Exhibit 40, at the point you executed the covenant, there was apparently a change of mind of some kind?
Oh boy, fuzzy, long time ago, but I think I remember we had conversations about, well, what if we wanted to improve the playground, which we then did. What if we, that wasn't a current historical use, that there be, a different kind of playground equipment, or if we wanted to, build an outdoor basketball court or something like that. We didn't want to, we weren't aware of the subdivision rules of what it would take to change the playground or things like that. So I think, we said, look, we're willing to file the covenant, but, subdivision laws changed quite a bit, and we didn't want to restrict our use of the property if we wanted to do something different, just in furthering the educational use of that space.
But at the time you all proposed Exhibit 55, you weren't willing to restrict yourselves that much, as I understand it, if I'm reading the document correctly.
To subdivision of the property,
Yeah.
given the restrictive covenants,
You said you checked no, did you not?
right, we check no.
Thank you.
So you had two choices there. First choice, they say, you intend to subdivide the property? You said no.
Right.
And then it says, if you don't intend to subdivide it, are you willing to lock it up as a school forever? You go, no, we're not going that far. That's why you check no on that.
Well, I guess, Your Honor, and this goes back, I remember the specific piece that said, in the negotiation process, we were very overt in stating our desires to retain it as a school. But we didn't want to tie our hands to the way we might change it as a school. Understand? That was part of our, and not really understanding, because it doesn't say that we're going to do anything different than a school, it just says preclude subdivision.
Well,
So if we wanted an early childcare,
yeah, it didn't say anything about tinkering with the definition of school. What it said was subdivision.
Yeah.
You know what that means. That means put in a bunch of houses.
I guess I don't know what that means. I
What
guess
do you
when I
think it means?
I thought it meant any time we had to go, if we were going to change the use of the property, that we would, I'll give you an example. If we were going to, add a wing for early childcare for preschool, and we were going to have to, add on some new space, I guess, I don't know subdivision law, but that was, an example of the restriction that we didn't want to encumber ourselves with. But I did say emphatically that there was never a discussion, never an intent. That's why we said we don't ever intend to subdivide. But, the second piece was just not limiting ourselves for our educational purposes. And if we were wrong in reading subdivision, that was probably negotiating Queen's Hall.
Nothing further, Your Honor.
Just one brief follow-up question. Will you turn to page 2 of Exhibit 55?
Yes.
I see that there is a underlined section there of 1 and 2. Does that set out your reasoning behind checking yes and checking, or checking no instead of yes?
Let me read through it real quick again. To the first point, yes. Yeah. Thank you, we did write it down. Yes.
And having refreshed your memory, can you tell us what your purpose then was in checking no to subdividing, but no to entering into documents to restrict subdivision?
Yeah, I guess we felt that the right of first refusal and the restrictive covenant covered our intents and restrictions on the property. And as it says here, did not wish to encumber or diminish our rights of use of the property.
Nothing further, Your Honor.
Do you have anything further?
Nothing further.
Thank you, you may step down.
May this witness be dismissed?
Yeah, you just stand right here, it's probably
Okay.
probably be useless.
Foundation calls Tom Stevens.
Please come forward and be sworn.
Do you solemnly swear the testimony you'll make will be the truth, the whole truth, and nothing but the truth, so help you God?
We do.
Please have a seat.
Will you please state your name for the record?
Thomas G. Stevens.
And can you quickly summarize for the court what your educational background is?
I'm a graduate of the University of Montana with a bachelor's in business administration with emphasis on economics. I did postgraduate work at the University of Oklahoma and Oklahoma State University in economics, but did not receive a degree. I am a member of the Appraisal Institute, which requires at a minimum to start with a degree from a 4-year accredited higher education. Then 7 courses which approximate 250 hours of additional education specialized in appraisal techniques, a minimum of 4,000 hours of supervisory appraisal activity with the designated member and passing the comprehensive examination.
Okay. And what is your current occupation?
Real estate appraiser,
And how long have you been in that occupation?
just a little over 30 years.
And can you just briefly again summarize your experience as an appraiser? As appraiser?
Yes, I can. After graduation from the University of Montana, I moved to the South where I started with a mortgage company as a real estate appraiser trainee. Worked for the mortgage company for 2 years. Started my education in the Appraisal Institute. Then took an assignment with a small savings and loan company in Stillwater, Oklahoma, and achieved the status of chief appraiser for Stillwater Savings and Loan. When the savings and loan wanted to put me in management, I decided that's not what I wanted to do, so I returned to Missoula and started working with Robert White, who held the MAI designation, and continued my designation and work experience to achieve the designation. Since that time, since 1978, I've been a full-time independent appraiser in Missoula, appraising both single-family residential and commercial properties.
Okay, and you mentioned MAI. Can you tell us what MAI is?
MAI just denotes a designation by the Appraisal Institute, which means Member Appraisal Institute, which holds out to the general public that I am competent in appraising all types of real estate.
Okay, so that's a professional certification?
Yes, it is.
Okay, and then in addition to that certification, do you hold any other certifications?
I do. I hold the SRA designation with the Appraisal Institute, which is for single-family residential, and I am also a certified general appraiser in the state of Montana.
Okay. And are you involved with any professional associations of appraisers?
Just the Appraisal Institute at this time.
Okay. Have you ever served as an expert witness regarding the appraised value of real estate?
Yes, I have.
And can you briefly summarize your experience in that regard?
Over the last 5 years, I have testified in both state district court, federal bankruptcy court, and federal court on various matters.
Your Honor, I'd be happy to stipulate his expertise and save some time.
Stipulation accepted.
Okay, Your Honor, we'll move forward and request testimony on opinion. Is that approved? He can offer his opinion.
Objection.
No objection.
Yeah. May I approach, Your Honor?
Yes.
Put in front of you, Mr. Stevens, what's already been admitted as Exhibit 15. Are you familiar with this document?
Yes, I am.
Okay. And can you just briefly tell us what it is?
This is the appraisal report that I prepared for the school district after being engaged by Mr. Bruce Moyer to do so.
Okay. And can you summarize for the court what your assignment or the scope of your appraisal was with respect to that document produced?
Simply to inspect the property and estimate the market value at its highest and best use.
And did you conduct that appraisal in accordance with generally recognized appraisal standards?
I did.
And in preparing that appraisal, what methods did you use?
There are 3 recognized methods to value property: cost approach, income capitalization approach, and sales comparison approach. And in this instance, I did not have any sales of similar properties as a whole. So I used or developed the cost approach and the income capitalization approach.
Okay, can you just briefly tell us what the cost approach involves?
Cost approach involves inspecting the property and estimating the underlying land value, and then also estimating the value of the existing improvements that are located inside.
And can you briefly just summarize what the income capitalization approach involves?
The income capitalization approach estimates the market value of a property that has income producing potential by either using the existing income that is being generated from the property or going into the market and estimating the economic rent which the property should generate if it were available to the public. That net income stream then is capitalized at a rate that's reflective of market transactions for an indication of value.
Okay, and based on your experience and the work you performed in connection with this appraisal, did you come to a conclusion as to the fair market value of the Roosevelt School property as of August 30th, 2004?
I did.
And what is your opinion?
$1,450,000.
Okay, can you describe for the court how your opinion of fair market was determined?
The property is very unique in that it involves one city block of land. I viewed the property and measured the building and found out there was approximately 39,000 plus square feet in the building. But my highest and best use of the property was estimated to develop the land along Stevens Avenue, which is single-family residential home sites, and to keep the building on site and use it as such until at such time the land value underneath the building would warrant removing the building.
And to reach that determination, did you use the cost approach, the income capitalization approach, sales comparison, or some combination of that?
I developed the cost approach and the income capitalization approach and gave them equal consideration in the overall correlated value.
Okay, can you explain briefly what you used to come up with your cost approach conclusions?
Well, I estimated the value of the underlying land and then estimated the replacement costs of the buildings less depreciation. That came to a value of $1,500,000. And then in the income capitalization approach, estimating the economic rent for the building, since I felt that the current lease was under market, I considered it but gave it little or no credence and capitalized the net income stream for an indication of value of $1,400,000. And then in the final correlation, I gave both approaches equal consideration for a value of $1,450,000.
Okay, so
just in my own mind to be clear, you're saying you disregarded the current lease on the property?
I gave, yes, if you want to put it that way, I did disregard it. I did develop an income capitalization estimate of value using the current lease, and I believe it arrived at $1,200,000, which I thought was too low.
Okay. So you actually considered a higher lease?
I did.
And if let me ask you this question, would your opinion change if somebody purchasing the building was considering demolishing the existing building and then starting from scratch?
No, my opinion would not change.
And in reaching your conclusion, and I think you testified to this, just to be clear though, did you come to a determination of the highest and best possible use?
I did.
And that was to keep the existing school, or existing building as a school?
Keep the existing building intact and use as a school, but I estimated the rent would be higher, or should be higher, than was currently being charged, and to develop the land along Stevens Avenue with single-family homes.
So is it fair to say that if there was some sort of restriction on developing the land, that would actually decrease your fair market value determination?
Yes, it would.
So in reaching your 1.45 million, you considered using the building as a school, but also in addition to developing that property?
That's correct.
Did you have a chance to review your August 30th, 2004 appraisal in 2005 to determine if your conclusions were still valid or you had some reason to change?
I did review my report based on several things, and I authored a letter to Mr. Moyer pointing out several typographical errors or incongruities, but I did reaffirm my value as of that date.
Any approach, Your Honor?
Yes.
Mr. Stevens, I've handed you a letter addressed to Mr. Moyer dated March 11, 2005. Is this the letter you're referring to?
Yes, it is.
And are we moved to admit this as Exhibit 56?
No objection.
Admitted?
And as of March 11, 2005, did you find any reason to change your opinion regarding the fair market value of the Roosevelt School property?
I did not.
Nothing further for this witness, Your Honor.
Exhibit?
Just briefly. Mr. Stevens, did anyone from the Missoula County Public Schools dictate the manner in which you would perform the appraisal?
I'm sorry, would you repeat that?
Did anyone from the Missoula County Public Schools dictate the manner in which you would perform your appraisal?
No, they did not.
And are you aware of any other appraisals that have been performed on this property?
No, I have not.
Thank you.
Exhibit?
Thank you. Mr. Stevens, thank you for coming in. My name is Roy Andes. I'm counsel for Good Schools Missoula in this case. Your appraisal was performed on the basis of the appraisal of real estate 10th edition, is that right?
I believe I said 10th edition in there, but it was with the 12th edition.
Oh, so saying the 10th edition was a typographical error on your part?
That's correct.
So if I held up this book and showed you that I'm holding a copy, well, what am I? What did I just give you there?
You gave me the appraisal of real estate, 10th edition.
Okay, so that's what you stated in your appraisal you were relying on?
Yes.
But even though this edition that you were referring to is, what, about 20 years out of date? It still contains valid appraisal principles, I assume.
I don't know that I would characterize it if I go back 20 years out of date. The Appraisal Institute doesn't update that book every year. So it's considered valid until the edition comes out. But yes, the appraisal theory changes
Slightly.
slightly, that's correct.
Okay. Is it fair to say that an appraisal does not determine fair market value, it is an estimate of fair market value?
That is correct.
And in fact, you so testified to the Board of Trustees long before this property was sold, did you not?
I did.
In fact, if I can remind you of a date, I'll ask you, does this sound familiar that you so said on to the Board of Trustees Finance and Operations Committee meeting of August 31, 2004? Does that sound about right?
That could be correct, yes.
So, being an estimate, in order to actually ensure that the property is sold for true fair market value, there are a number of conditions that apply. Is that not true?
To which do you refer? I don't know if that would be true. or not.
Sure, let's cut to the chase. If you'd be good enough, I'm going to ask you to read from the Appraisal of Real Estate 10th edition, page 21. If you would read the paragraph that follows from the highlighted text there.
Certainly. The most probable price which a property should bring in a competitive and open market under all conditions requisite to a fair sale. The buyer and seller each acting prudently, knowledgeably, and assuming the price is not affected by undue stimulus.
There are several more conditions too, aren't there?
Well, you just said what is
Oh, I'm sorry,
That's
yeah,
what I read.
excuse me. If you'd read the condition, the 5 conditions under there as well.
Buyer and seller are typically motivated. Both parties are well informed or well advised and acting in what they consider their own best interests. A reasonable time is allowed for exposure in the open market. Payment is made in terms of cash in U.S. dollars or terms of financially arrangements comparable thereto, and the price represents the normal consideration for the property sold, unaffected by special or creative financing or sales concessions granted by anyone associated with the sale.
So, I take it you would agree, thank you very much, by the way, you would agree that those are the conditions that the Appraisal Institute has determined are the appropriate conditions to obtain fair market value from the sale?
Yes.
I'm going to hand you Exhibit 40. It's entitled Declaration of Restrictive Covenant. Have you ever seen that document before?
I have not.
You were sitting in the courtroom a few moments ago when people were testifying about it, were you not?
I was.
Did you hear them describe generally that this covenant restricts the use of the property for use as an elementary school during its ownership by Loyola Sacred Heart Foundation?
I did hear that.
And that this covenant expires on resale by Loyola Sacred Heart Foundation?
I heard that as well.
And that there's a right of refusal, first refusal to the school district to match the resale price at the point in time Loyola sells it.
I did not hear that, but I will take your word for it.
Okay. This kind of condition that you just described, or covenant rather, would that tend to constrict the market value that one could get for in the sale of property?
It could, but in the case of my appraisal, which was dated August 30th, 2004, it was prior to that, as I see it, it did not have any influence on it.
Right, so you didn't know about it, so it couldn't have any influence on it.
That's correct.
So these conditions came up later and were not a factor in your writing of the appraisal.
That's correct.
Now, you were given the assignment to do this appraisal something like July 13 of 04,
I believe that is correct.
and you had to render your opinion on August 25th of 04.
Actually, I was engaged on July 28th, 2004.
Okay. And your opinion then was rendered August 25th?
Possibly my preliminary opinion was rendered August 25th to the board. I can't recall if I did that prior to completing the report.
That's a pretty fast turnaround on a job of this magnitude, isn't it?
For me, yes.
I mean,
To be honest.
you have to do a lot of work in a very short period of time, right?
That's correct.
Okay. And I understand to be your testimony that the lease, the then existing lease at $60,000 a year, you thought to be a below market lease.
Yes, I did.
Did you have any information at the time you prepared the appraisal as to whether this lease would be continuing beyond In other words, whoever purchased it would have to take the property subject to the lease?
Well, just as a matter of course, I assumed that whomever purchased the property would have to honor the existing lease, yes.
So if the property is encumbered, in your view, with a lease that was below market value, would that not tend to restrict the price that people would be willing to pay for that property?
I would have taken that into consideration if it were a long-term lease. But the remaining term, as I recall, was less than 5 years, 4 years and change. So I thought it would not unduly depress the overall market value of the property. So I did not take it into consideration in that respect.
However, a covenant that it be used only as an elementary school for some extended period of time would do so, I believe you testified, right?
So the covenant was not in place when I appraised it.
Right, excuse me, a restriction that it be used only for an elementary school would decrease its value.
And I knew of no restriction.
Just a second, you guys are overlapping.
I'm sorry.
So a restriction that it be used only for an elementary school, I think I'm quoting your previous testimony, but tell me if I'm wrong, that's what I'm asking. In other words, if it were restricted to use as an elementary school, that would constrict the pool of bidders and probably therefore constrict the price as well, right?
It could, but I don't recall that. Well, I know my appraisal was not predicated on it being restricted.
Right, in fact, the highest and best use was to sell those residential lots as residential lots, was it not?
That's correct.
If the property is subject to this covenant that we've just talked about, so that it can only be used as an elementary school for the life of Loyola's ownership, but then on resale it can be used, zoning permitting by Walmart potentially, that would mean on resale it can be sold for a substantially greater price, would it not?
I don't know that.
That would be likely from an economic standpoint, would it not?
You're asking me to make a projection on future value that I cannot do. I haven't done that research.
But isn't it general economic theory that when you constrict the uses of property, you tend to restrict the value of that property as well?
In general, but I don't know in specific that that would be correct.
So it doesn't necessarily happen, but in general, that's an economic principle. Is that your statement? Okay. No further questions. Thank you.
Redirect.
Thank you, Your Honor. Mr. Stevens, during the course of your appraisal and conducting your appraisal, did you have any conversations with anybody from the Loyola Sacred Heart High School Foundation?
No, I did not.
And to understand your testimony, you did not take into consideration any restricted covenant or restricted use when you determined the fair market value in your appraisal?
That is correct.
So it's fair to say that if Walmart wanted to purchase this property in 2005, your opinion to them would be the property is worth $1.45 million.
That's correct.
Has anyone ever challenged the veracity of your appraisal, or?
Objection is beyond the direct scope of cross, Your Honor.
Your Honor, he just challenged the veracity of his appraisal.
I did not.
I don't know what you were doing if you weren't. You can answer the question. I mean, I assume he did because in his letter he said, I got a lot of challenges to my appraisal and beside a few typographical errors, I'm standing firm on my appraisal, right?
That's correct.
That's not exactly what I was getting at to you. Has anybody taken any action to challenge the veracity of your appraisal?
Yes, they have.
And what was that?
An anonymous complaint was sent to the Appraisal Institute.
I would object for relevancy and beyond the scope of cross, Your Honor.
Your Honor, he's challenging the veracity
So
of the appraisal.
what are you attempting to show, that he's got some nasty people that...
No, not at all, Your Honor. What I will show through his testimony is that a complaint was filed with the appraisal board, that they reviewed the appraisal and reached a determination that it was conducted in accordance with the generally accepted standards.
In which case it's hearsay.
Are you going to offer a letter or something from the board, or because he's objecting to...
Right, Your Honor, Mr. Stevens has a letter. Do you have that here?
I do.
Have you seen it?
I think I probably have several years ago.
Go ahead, you can answer the questions then.
Okay. Has anybody officially challenged the veracity of your appraisal?
As I was stating, an anonymous complaint was submitted to the Appraisal Institute indicating that they thought my appraisal report, and I don't know the exact words because the Institute does not inform me, number one, who submitted the complaint, or number two, the verbiage in the complaint. I voluntarily submitted my appraisal report and supporting documentation to the Institute. They reviewed it and closed the file saying that, and stated that I performed the appraisal according to USPAP standards.
And do you have a copy of that letter?
I do. I have it in my file. It may take me a second to locate it.
May I approach, Your Honor?
Yes.
It may take
If we open this door, do you want to spend a lot of time on this question? Because in order for me to put weight on the rubber stamp or whatever it is that the board gave him, I need to know if they did something more than, oh, Tom Stephen from Missoula, he's a good guy, sounds good to us. Or did they send someone out who walked through the measurements and looked at every single document that Mr. Stevens looked at and brought in a couple of experts from wherever, so that I can put great validity on their affirmation of his appraisal, or what?
Well, Your Honor, I was just simply going to admit the letter and you can give
I
it
know,
whatever
but
weight you
what
like.
weight do I put on it?
Well,
Right
I
now-
think
right
it
now
is-
it's 0.
Well, I think it's full faith and credit that the,
I don't know these people.
well, it is the Appraisal Institute, which is the, well, I can ask some questions about what the Appraisal
But
Institute.
whatever, however you want to
Okay.
spend your time.
Mr. Stevens, what is the Appraisal Institute?
The Appraisal Institute is a national, actually it's an international organization of professional real estate appraisers who have promulgated professional designations and the education and experience requirements to obtain those designations. Then they also police their members as to appraisal practices and standards, and if the appraisal reports are prepared under the uniform standards of professional appraisal practice.
And you had earlier testified the certifications of MAI and SRA, is that correct?
That's correct.
And that is through the Appraisal Institute?
Yes, it is.
And it's your understanding that they can remove those certifications if there's problems with your work?
In a heartbeat.
Your Honor, we'd offer this as an exhibit. How is that?
No objection to the foundation, but I do object to hearsay and relevance.
That's admitted.
What's the number on that?
That would be 57, Your Honor. And if we could get copies of that. That was the only copy we had. Nothing further, Your Honor.
You have a request?
Nothing.
Thank you, sir. You may step down.
Thank you.
Wait, before you leave, Ms. Stevens, when I'm reading this, I'm trying to decipher the code.
Okay. Go ahead.
So you send them your appraisal report, and then, based on the information I have regarding the above matter, which would be the appraisal report, and as we discussed by phone, he must have called you or something,
Yes.
I decided to close this file after discussing with you certain standard issues for educational purposes. That oftentimes will be code for you made a lousy report, or you got a lot of typographical errors in here, or just so you know you won't do it again. What's the code for educational? I'm discussing to use certain standards for educational purposes. The reason I ask that is when I see that kind of language, that's usually nicey talk for something that somebody did wrong.
Ms. Coleman and I had two telephone conversations, one of which I asked her to call me or email me when she received my appraisal report so that I know that she had it, because there is a certain amount of time that cannot elapse from their request till I submit it. She called me, said she had it, she would review it. And the date of that letter, I don't, what is the date of that letter?
April 1905.
Several months went by. I did receive the phone call that she was talking about. We talked about some typographical errors in the report. There's a disclaimer in the report that I try to disclaim away my liability as far as environmental constraints and concerns as far as asbestos.
I saw that about, wasn't asbestos, but it was something else.
Yeah, and she said, you know, you really can't do that. You need to reconsider doing that. She corrected the 10th edition to the 12th edition, and that's it. That's all I
Okay,
need.
that answers my question. It's exactly what I wanted to know. Do you have any questions based on mine? Okay, thank you very much.
Yeah, thank you.
May this witness be dismissed, Your Honor?
I was right, wasn't I? Nice talk for, you omitted something in there.
Yes, you were.
Work on spell check.
He may be dismissed.
Yes, he's done.
Pursuant to our pre-hearing order, Your Honor, the next witness to be called will be Janet Scott. She's got the emergency, so we're simply going to admit her deposition.
Okay.
May approach, Your Honor, here's the original.
No objection to this?
No objection.
Your Honor, we would call Dan Funch.
Please step forward. Be sworn.
Do you solemnly swear the testimony you will make will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Permission to treat Mr. Funch as adverse, Your Honor.
Okay. Any objection to that?
Mr. Funch, what is your position with Good Schools Missoula?
I'm president.
And when did you start that position?
In 2006.
Okay, and as the president of Good School Missoula, are you aware of the activities of Good School Missoula?
Yes.
You attend the board meetings? Are you also on the board of Good School Missoula?
As the president, yes.
Were you aware that Good Schools Missoula was going to initiate this litigation against Loyola Sacred Heart High School Foundation prior to it being filed?
Yes.
And did you approve of Good Schools Missoula taking that action?
Oh, yeah, I did.
And prior to initiating that action, did Good Schools Missoula board and the officers, yourself included, get opinions from its members regarding claims to be filed against Loyola Sacred Heart High School Foundation?
We did.
It's fair to say those would be certain complaints that they had regarding the sale of the Roosevelt School property?
Yeah.
And one of those complaints was, in fact, that it would cause additional air pollution. Is that correct?
Yes.
In fact, that was one of your sort of pet
It's kind of one
complaints.
of my pet peeves, yeah.
And that's because you live in that neighborhood?
Well, it's also because I have a high level of environmental concern.
And what other concerns did you have about the sale of the Roosevelt School property?
There were, I would group them into a few categories. One is similar to the air pollution, environmental concerns, and how selling the neighborhood school would lead to increased busing throughout the community. I also had concerns about traffic and safety in the neighborhood and how that might increase as the school went from public to a private institution. I also had concerns about, as a taxpayer, the fiscal implications of the sale and how increased busing costs would be passed on to taxpayers, and how I felt that we, as many of our members did, that we were losing a valuable public asset that would be very difficult and costly to replace should we need it. And with the projections of growth in Missoula, I thought that was kind of a no-brainer, really, that we would need neighborhood schools. And so the fiscal implications of the sale were quite large in my mind, and many of our members as well.
Okay. So it's fair to say that you were concerned with selling the school, that it would cause additional air pollution, additional traffic, and it may create more expense for the public schools down the road.
Yeah.
Did you have any concerns about the price received for the Roseville School property?
Yes.
Okay, and what were those concerns?
We felt that essentially the school was sold in a sweetheart deal, that it was a price that was not reflective of fair market value, that while it did meet the appraisal, I personally did not place great faith in the appraisal, having gone through several of my own. It seems mysterious that, you know, a buyer and seller agree on a price and, oh, that's what the appraisal comes in at. So I was suspect about the appraisal and felt that it did not reflect fair market value for that property. And living 2 blocks away, it seemed to me that that was worth much more than what we paid for it, or what we sold it for.
Okay, and you said that, have you seen any other written appraisals of the property valuing it greater than 1.45 million?
I have not.
And you said that a buyer and a seller came to a price, and that price ended up being the fair market value in the appraisal.
I said that seems to be the way appraisals work.
Okay. Are you aware of any situation in which the foundation of the public schools in this situation came to a price of 1.45 million?
I am aware that the Sacred Heart Foundation made an offer of 1.1 million before this deal was arrived at, but I'm not aware of any specific agreements they reached before the appraisal in regard to the 1.45 million price.
But isn't it true that the $1.1 million offer was actually made by the Missoula Catholic Schools and the Helena Diocese?
It may have been.
Are you aware of any prior offer made by the foundation for the purchase of the Roosevelt property prior to their formal written proposal of 1.5 million?
No. I didn't really distinguish between the Catholic schools and the foundation.
You do understand, though, that the foundation is a separate corporate organization?
Now I do, yeah.
Okay. Did you understand that before the Good Schools Missoula filed their complaint?
No.
And you don't dispute that $1.5 million is greater than $1.45 million?
No, I don't dispute that.
Prior to filing this litigation, were you aware that the foundation had paid $1.5 million for the property?
Paid 1.5. Yeah.
And just to refresh my memory, you had or were aware of Thomas Stevens' appraisal prior to filing the litigation?
Yeah.
Is it fair to say that you were also upset with the process by which the public schools chose to sell the property?
Yes, I felt it was hurried. I felt it was rushed and didn't give time for full consideration of what might have been more lucrative offers.
So, just to be clear, you were upset with the pollution implications?
Pollution and environmental in general, traffic, busing, sprawl. How this would contribute to sprawl.
The financial viability of getting rid of a school that the public schools could use?
We might need, yeah.
And the process by which the public schools chose to sell it?
Yes, and what I might sort of call, favoritism or benefit, like where one party had been sort of pre-selected and a deal had been made without sort of letting the public process run its course.
Okay. And but you're aware that the proposal that the foundation responded to with the $1.5 million offer was also sent out to other bidders?
Could you restate that?
Well, were you aware that the proposal that was sent out to the foundation, which they responded with a $1.5 million offer, that same proposal was also sent out to other bidders?
I was not actually aware of any request for proposals that the district did, and I was expecting to see and read and hear about that, and I didn't hear about that.
So you were unaware that that proposal went to a Mr. Coors?
I was unaware that it was made generally available, like in a request for proposals, an RFP format. That's kind of what, to me, triggers a public process for selling anything, and I didn't see one in this case.
Okay. So you never saw the request for proposal prior to filing this litigation?
No. Myself, no.
You weren't aware that a proposal was also submitted by Mr. Smith?
No, I heard that other proposals were submitted. I was not aware that a request for proposals had been put out.
How did they put out requests?
I don't know, Your Honor, the foundation simply received one. You can ask the public school how they submitted it.
You don't have a clue?
I have no clue, Your Honor. We received a request for proposal, we made a proposal.
But you knew somebody else? You asked a question about him being aware that there were other requests made.
Right, certainly through discovery, I've discovered that there were other offers made.
Well, it's an offer and request are not the same thing.
That's right.
Let's use our words carefully. I'm asking about requests.
Right.
Were there other people that received a request?
The only ones that I know of through discovery, Your Honor, were Mr. Corse and Mr. Smith, and that's because they responded to the offer. I don't know if they were sent out to anyone else.
I guess that would be your exhibit number 54. That's the
That is the
best
proposal.
offer process.
Correct, Your Honor.
Was it ever sent out to other people?
Your Honor, the process the district followed was to publish that it was seeking sealed bids. It was soliciting sealed bids from the general public regarding the purchase of that property. So that's the process it followed. A request for proposal process that Mr. Funch is referring to was not used.
Who else got this document number 54? It's called the Roosevelt Last and Best Offer Process and Timetable.
Your Honor, those documents were available for any interested party who requested them from the district. I don't know exactly who picked up a copy of it, but I can tell you who responded to the request.
And this is what you got.
That is what the foundation received.
Got it in the mail.
I can't say it was received in the mail. They may have stopped and picked it up.
Are we addressing his concern? His concern is it wasn't made known to everyone.
Your Honor, as far as I know, it was actually published. And I assume that the public school is going to put on testimony that it was published.
It was published somewhere, and then the people that asked were told, come down to the office and pick this up, or we'll send you one in the mail, or something like that.
It was published, Your Honor, and interested individuals were encouraged to either come by the Missoula County.
It was published in the
Missoulian.
Missoula.
Yes, as well as it was brought out during comments during public board meetings and recorded in those meetings.
So you'll ask him about that when you
I
come to your
will.
turn. Okay, all right, sorry, I'm getting ahead of myself.
And so just to backtrack a little bit, it's fair to say that you had a dispute with the process by which it was sold.
Yes,
And you just believed it was sold for less than it was worth.
that's not the only thing I believe.
Right, I agree. I guess with respect to that category, you simply believed it was sold for less than it was worth.
No, I mean, when you say process, I must include my concern about the lack of open bidding and the insistence on the seal bid process, and then again, to reiterate, the fact that I was not aware of a formal RFP process.
Okay.
My expectation was that's how government agencies and elected bodies work, and when it didn't happen in this case, that raised alarm bells for me.
Okay, so that was your category of process. That's
That's right.
the issues you had with the
That's right.
process. And you had issues that this was going to create additional traffic, air pollution, what I would call environmental concerns.
Environmental and taxpayer concerns were my substantive concerns.
And the taxpayer concern was that you were getting rid of it, the public schools were getting rid of an asset that they might need.
Without a facilities plan that would have demonstrated the need or lack thereof for that school, I felt, and I testified to this to the school board in the years leading up to the sale, that the lack of a facilities plan was of great concern to me and other neighbors. And that's indeed is one of the reasons we formed our group.
Okay. And then the final category was you believed it was sold for a price below fair market value.
Yes.
And you based that simply on your own personal opinion.
Yes.
You've seen no official appraisal greater than 1.45 million.
Yeah, I'm not an expert on appraisals.
Have you talked to any certified appraiser who told you it was worth more than 1.45 million?
No, unless someone is a certified appraiser and I didn't know it.
Nothing further, Your Honor.
We can have it.
Mr. Funch, you've been deposed twice in this matter, is that accurate?
Yeah.
Okay. And do you recall the topics of conversation that we discussed during your prior depositions?
Vaguely.
Okay,
I know air pollution was one of them.
okay, yes. And Good Schools Missoula was incorporated in April of 2004, is that correct, or 5? Do you recall?
I don't know the exact.
Okay, actually,
I'm sure you've
in
got
April
it
of
there.
2006, does
Okay.
that ring a bell? Okay, and you're the president of Good Schools Missoula,
Yeah.
is that correct? Do you recall the Good Schools Missoula Board approving a resolution to support this litigation?
Yeah,
Okay, do you recall when that resolution was signed?
not the exact day. It was right around the time that we filed the litigation.
When it was signed?
Yeah, it was in the neighborhood. It was right around there.
Okay, do you recall testifying that the actual resolution itself was signed on June 22nd of 2006?
The actual resolution approving the litigation.
Yes.
I don't recall that.
Okay.
But if that's what we did, then that's what we did.
Okay, may I approach, Your Honor?
Yes?
Dan, I'm going to hand you a copy of a transcript of your deposition and ask you to refer to page 17. Starting on line 1, could you read the questions and answers down to line 6?
Okay, one, answer. It looks like Janet Scott. And what date did Janet sign that on? 6/22/06. So the document was originally dated on April 9th, is that correct? Yes. So when the document was originally dated, Good Schools Missoula as a corporation didn't exist, is that right? Answer. Good Schools Missoula was incorporated April 11th. Question, right. So as of April 9th or April 4th, whichever date you take, it was not incorporated, is that correct? Answer, correct. But, should I keep going?
No, that's good. Thank you. So does that refresh your recollection regarding the date of the
Yeah.
incorporation or the date of the resolution?
Sure.
Okay. So is it accurate to say the resolution was not signed by Janet Scott on behalf of Good Schools Missoula until June 22nd?
Sure.
Okay. And Good Schools Missoula was actually incorporated following, excuse me, on the same day that this litigation was filed. Is that correct?
I believe so.
But the board didn't approve the litigation, or Good Schools Missoula didn't approve litigation until
Objected, right?
approximately 2 months later.
What's your objection?
Irrelevant.
What's the relevance? Let me understand, you're saying they were incorporated, same day they filed the lawsuit, but they made a formal approval of the lawsuit sometime later.
Yes, Your Honor, what we're going to do as far as relevance is to demonstrate that this entity was designed specifically to go forward with this litigation, but the entity didn't actually approve the litigation until following 2 months into the process.
And
Still irrelevant.
And the point of that is what?
Is individual members of Good Schools Missoula weren't necessarily always aware of what the actions of the group were, and that will become relevant as we present more testimony.
Okay. So you're just laying some foundation now
Yes.
for it. And so your point, if you establish that, is what?
Is that individual members of Good Schools Missoula weren't aware of sufficient facts to
Yeah.
maintain this
And
case.
therefore what? And from that I infer what?
That there wasn't a reasonable basis for filing this case in the first place, Your Honor, which is the basis of what
So
we're talking about.
you need everybody in the whole organization to agree to something before there's a reasonable basis, or what?
No, not necessarily, Your Honor, but Mr. Funch was the president of Good Schools Missoula, and I can demonstrate that he wasn't aware of specific facts that are particular to this case and would justify it as being a reasonable case in its inception. As one of the officers, he's identified as an individual that had very specific knowledge, and through prior testimony, we were able to establish that he did not have that knowledge.
So we're talking to the clueless president now.
Well, I'm not going to call him the clueless president.
Well, that's just what you said.
Well, I'm
He's
going
a
to say,
clueless president, he didn't know what these other members were up to.
he didn't have the basis of knowledge that he was identified as having when we went through depositions in this case, Your Honor.
So was he clueless at the start with, or clueless at the deposition, or what?
It's going to be our contention that Good Schools Missoula in general didn't have sufficient facts, including their individual members, to maintain this suit. That was started at the inception and continued to today.
And I guess I continue to object to relevancy because no one member in a case like this is going to
Well,
know
what I'm trying to
everything.
figure out is like, you want to pin the attorney fees on the whole group or just a couple of troublemakers in it?
Your Honor, Mr. Funch was identified as a 30B6 witness to have very specific information, and when he was deposed, he was unable to give any of that information.
On one specific topic, Your Honor, and that was air
Well,
pollution.
wait, I'm handling it okay for
Sure.
you, so.
Sorry.
I'm having trouble following you here because you want them to pay your attorney fees. And so are you showing that there are a whole bunch of loose cannons that didn't know what they were doing but got a corporation and then filed a lawsuit the same day and then kind of gathered it together over the following months? Is that your theory?
My theory is they never gathered it together, but what my
Oh.
theory is that essentially is that this lawsuit was filed without a reasonable basis in fact. And I need to demonstrate that to you by talking to individual members who've been identified by Good Schools Missoula as the individuals who should have had that
Okay.
knowledge.
All right, so when you're after a clueless one, say clueless, and is that a too harsh a word?
Well, I like Dan, so I'm not going to call him
How about,
clueless,
how about
but
uninformed?
an uninformed witness. It's my contention.
An
that-
uninformed member
An
of,
uninformed member. It's my contention he's uninformed about the areas that he was designated to be informed about.
designated or took it upon himself?
He was designated as a 30B6 witness, Your Honor, to have specific information regarding the alleged injuries regarding air pollution and traffic patterns and busing issues with regard to Missoula County Public Schools.
Which goes to standing, Your Honor, and therefore is irrelevant because it's already been ruled on by the court. That's a standing issue only.
I'm not following you there.
And,
The issues with regard to air pollution, with regard to, oh gosh.
Oh, yeah, I'm
busing,
aware.
all those kinds of things.
I'm aware that Judge McLean approved standing.
And those issues go to standing only, they don't go to the merits of the case.
Well, they're saying that they do go to the merits because you may have standing to bring a lawsuit, but at least you have to be halfway informed about
But
it.
his 30B6 notice was specifically with regard to traffic and air pollution. That's all. And so that was a standing issue only, that's already been ruled against them by Judge McLean, so it's entirely irrelevant to this proceeding.
Your Honor, I would disagree.
You're not challenging standing, you're just saying that they just got the lawsuit going without having a reasonable basis to get started.
That's exactly it, Your Honor. I'm
And
not
so far I've
challenging.
heard that he had some opinions about a variety of things, and that the resolution came in a couple of months after they started. But I'll let you keep going, I'm maybe getting ahead of myself. I haven't tied it all together yet. You're not clueless, just not.
No. Okay, Dan, did you review the complaint prior to it being filed?
Yes,
Okay, including the specific allegations with regard to the value of the property?
yes,
Okay. And the alleged damages that Good Schools, unnamed Good Schools Missoula members were going to be alleging?
yes.
Okay. And did you personally, as an officer in the corporation, have enough knowledge or specific knowledge to verify the facts underlying those complaints?
Well, you know, the reason that we retained counsel was because as individuals, we did not have the expertise that we felt was needed in areas of law to bring the case forward. That's why we retained counsel.
But I'm not asking you about the legal expertise. I'm
Sure.
asking you about the facts that underlie the complaint, so the allegations in the complaint itself.
I felt I had sufficient knowledge to move forward as president of the organization, sure.
Okay. And do you recall testifying that prior to our deposition in October of 2006, you hadn't even reviewed Tom Stevens' appraisal?
I do remember saying that, yeah. And the reason I hadn't was because others had. And I had great confidence in them and their insight and evaluation of that.
Okay.
As president of the organization, my job was to, recruit members, build a team, trust the people that you recruit, and work with others that had much more experience in the particulars of this issue than I did.
Okay.
Excuse me, you used the word reviewed. Reviewed means to me that he looked at it in detail and read it over a couple of times and kind of picked it apart. He's acknowledged he didn't review it at that level, but his answer indicated that someone else had, and that someone else who he relied on told him what the appraisal was. Is that true?
Yeah.
They told you the dollar amount?
Yes.
Okay. So Dan, you relied on the opinions of other Good Schools Missoula members, is that correct?
Yes.
And And are any of them appraisers to your knowledge?
Not to my knowledge.
Okay. Did you even read the appraisal of Mr. Stevens?
I honestly can't remember. I may have read it between now and then.
And so
Between
did,
today and then, or?
Between today and then.
Oh, okay.
okay.
But she's asking out, she really means between when you filed a lawsuit and when it was authored by Fraser Stevens. That,
Yes.
Before we filed the lawsuit, I did not read his appraisal before we filed the lawsuit.
Okay. And can you identify any Good Schools Missoula member who did?
Yes. I could.
Please do.
Well, I believe that others that will testify today reviewed it.
That's not, I'm asking if you can identify a Good Schools Missoula member who reviewed the appraisal and reported to you about its contents.
Well, our attorney, Roy, reviewed the appraisal.
Is Roy a Good Schools Missoula member?
I haven't checked our list yet. I don't believe he is.
Okay, so what I'm asking you more specifically is, can you tell me a member of Good Schools Missoula that reviewed the appraisal and reported to you about their opinion?
Well, what if I could, but I didn't want to because they wanted to be anonymous? We have a lot of members who joined our group because, and this is one of the reasons we formed an organization, because a lot of people feared retaliation and harassment and didn't want to have their membership public.
Okay. So, are you claiming a particular kind of privilege?
Actually, yes, Your Honor, we are. Under the NAACP versus Alabama authority that I provided to council some 3 years ago. For members who wish to remain anonymous, they have that right, authorization. If there are people who have waived that right, and quite a few have, and many of them are here today, certainly we'd be free to name.
well, coming here today doesn't mean you waived the right.
I think the ones who come here today have waived it.
So, it's my understanding, you have this information, but you won't reveal the source of it, is that correct?
Well, I think Carol, it's safe to say that Carol Pellin reviewed it, and we talked about that.
Okay, and is Carol an appraiser, to your knowledge?
Council, we need to take a recess here this morning. About 15 minutes, council start about 5 to 11.
Okay, thank you.
Your Honor, could we get a time estimation of where we are, so
Just ask her at your convenience.
Sorry?
Ask her at your convenience.
Okay, thank you.
Go ahead.
Mr. Punch, in the interest of time, I want to move specifically to the topics that you were designated as the 30B6 deponent for. And what that means is that Good Schools Missoula identified you as the person that would have specific knowledge regarding some alleged injuries. So do you recall those topics, air pollution?
I believe so.
And busing, okay.
Your Honor, may I have a continuing objection to that testimony since the issue has been resolved already?
Is this an issue about standing? It's not, is it?
No.
It's an issue with regard to air pollution, which is about standing.
No, I think her point is that you claimed air pollution, but it was either unresearched, fabricated, or flimsy.
But that doesn't go to the merits of the case, Your Honor. That goes only to
I know it
standing.
doesn't go to them.
And standing has already been ruled on.
It doesn't go to the merits of the case. It goes to whether or not you had a reasonable basis for initiating a lawsuit. Am I correct?
Correct.
I have this question, though. Has Good Schools Missoula and its lawyers sorted out who they're going to blame between the two of them?
I'm sorry, Your Honor. I'm not following your question.
He said, I gave this to my lawyer. He looked at the appraisal. The implication is that the lawyer's to blame.
That's a fair implication.
Yes. And so, has that been sorted out so that I don't have a mini battle here between which of the two plaintiffs are evil, the lawyer or the plaintiff?
Clearly the lawyer is evil here. I did I did virtually all the fact research for this case myself, with a great deal of assistance from the members. And so it's sort of pointless to ask any one member anything about the
And
facts.
therein is where I'm going, is that's the one you're after. As in,
Yes.
that lawyer.
Well,
Because he says, I did the research, I'm the one that told them, you have a good case, let's sue them.
In essence.
In essence,
well, Mr. Andes has identified himself as a fact witness, and we will be discussing why he didn't name himself as a fact witness for 30B6 or in his knowledgeable persons list. That will come up.
And so his objection is that I'm overruling his standing objection, but I should let you know that I think the theory of the plaintiff's case here is it's not really these people's fault. They turned it over to their lawyer, and their lawyer reviewed the facts and made a recommendation.
And I'm hearing that now, but at the same time, Your Honor, Good Schools Missoula identifies for a 30B6 identification, Dan in particular is having this knowledge. I'm just trying to I guess, get on the
Well-
record that he actually didn't have that knowledge.
Well, he is using the lawyer cover.
He did for one portion of it, very specifically. That was the appraisal. This is now the air pollution. Mr. French.
Objection's overruled, you can answer.
Excuse me, sorry. Mr. French, you were brought in to discuss the air pollution problems due to the district's busing program. Is that correct?
Yes.
Okay. And what specific knowledge did you have regarding the busing program with Missoula County Public Schools when this case was filed?
Not sure what you're asking. What specific knowledge about the busing program?
Did you have specific information that there was increased pollution due to the busing of Missoula County Public Schools?
I did not have specific information, but that was my contention.
Okay, and that was based on your opinion?
Observation.
Okay. And were you aware of how many buses were run by the district in 1999?
I don't recall the number now.
Okay. Do you recall how many buses were run by the district in 2006?
I don't recall that number right now.
Okay.
Was that in my deposition?
You weren't aware of it? Would you like to see your deposition?
Sure. That's right. I believe I did file an information request with the district to get this information.
Okay. Had you filed that request when this lawsuit was filed? By the time this lawsuit was filed?
I don't have a copy of it. I don't know the exact date. It was, I think I got that. I think I filed it after we filed the lawsuit.
Okay. Your Honor, may I approach?
Yeah. Want to get just a second? Want to?
I was more concerned about a relative increase in busing. I didn't know the absolute numbers, but it sort of follows if 91% of the kids walk to Roosevelt School, and then Roosevelt School is closed as a public school, those kids are then bused elsewhere.
Okay, and with regard to the 91%, what are you basing that figure on?
Well, that was actually a League of Women Voters study that was done.
Okay. And was that information produced to the district?
I believe they submitted it to the district.
Do you know for a fact?
I don't know for a fact, but they publicized the report.
Okay.
Your Honor, if I may just have a continuing objection, I won't keep jumping up, but I think this is totally irrelevant to the issues before the court now.
Your objection's noted.
Thank you.
Continuing.
Dan, I'm going to ask you to read from page 9, just from line 5 down to line 13, please. Slow it down.
Sorry.
We talk fast.
Line 5, this is me speaking. What I know is that the increase in busing caused by the closure of Roosevelt School and the roughly 200 or so students there, adds up to that requires roughly 4 to 5 buses minimum to service those kids. And then the question is, okay, but you don't know how many buses they ran in 1999, do you, Missoula County Public Schools? Answer, I don't have an exact number.
It's So Dan, is it fair to say that your concerns about pollution, about traffic patterns are based on your observations and your opinion?
That's partially true.
Did you receive any information or opinion from your attorney regarding traffic patterns or pollution?
No,
Okay.
not that I can recall. We had numerous conversations. He may have had some research of his own. I can't recall.
Okay, that's all I had.
You may examine now or reserve the right to do that.
No questions, Your Honor.
Thank you, sir. You may step down.